each and every one of you. Good evening and welcome to Swala Nyeti. My name is Hari Karanja, lead podcaster at Swala Nyeti. In today's session, we are going to be celebrating an auspicious holiday or an auspicious event. Today marks 365 days since a small claims court was operationalized. And to celebrate this very exciting day, we will have 10 diverse speakers today speaking about their different perspectives on what this court means to them. Our speakers are drawn from the legal sector, judiciary, business, academia, and the common mwananchi. And we expect that we shall richly benefit from the input on the issues that shall be discussed today. And although each of our speakers has an amazing perspective, we also wish to hear your voice, you, the audience. Please follow us on our social media pages or just put in a comment with the hashtag Small Claims Court, and we shall try and ensure that the speakers respond to the questions and the comments you raise before the end of the session. So strap in and get ready to enjoy 1.5 hours discussing one of the most exciting things that has happened in our judicial sector for the longest time. Today, we are speaking about the Small Claims Court as it turns 1 year old. Now I'm going to invite each of our speakers in turn when they come up to give their remarks. So I want to begin at the best place, which is with one of the chief proponents of the Small Claims Court. Our first speaker is none other than the president of the Law Society of Kenya himself, President Eric Theuri. Welcome, President Theuri. President Theuri has been with this court since its infancy, and we lawyers owe him immensely for his tireless sensitization of the court through various trainings conducted across the country. And I want to begin by hearing his voice, the voice of the LSK president. President Theuri, what is a small claims court and why was it set up? Welcome.
Thank you, Harry. Hope you can hear me.
We can.
All right. Thank you so much for putting this together. Quite thoughtful of you to do this. And I think you've also been part of this journey. You have participated at the bar bench and training the other courts. So I think the success that the court has shared has been also partly because of the kind of participation that you have given it. But the Small Claims Court is basically a court that deals with claims that are below Kenya shillings 1 million. But that jurisdiction is also limited to a few claims, personal injuries, claims over contract commercial cases. So it doesn't have as wide as jurisdiction as the other courts. I think the jurisdiction of it is found, if I'm not wrong, in Section 12 of the Small Claims Act. And so this ideally is a court that is supposed to enable the ordinary mwananchi to have quick access to justice on in matters that are commercial in nature. The idea behind it, I think, was to facilitate the ease of doing business within the country, because you would realize that a lot of cases that are of a commercial nature, of sums that are below perhaps 1 million, have tended to be sort of in a way unattractive for people to use it, to use the court system, because of the cost involved in terms of one, getting a lawyer, but two, and most importantly, the time that it will take to clear such a process. And in some of these cases, actually in most of those cases, you would find that the claims in themselves are not well documented, because sometimes commercial transactions are made on the basis of trust. And so because of the large number of claims that had been locked out of the court system, or the large number of claims that were still being processed in the court system, and you see, for businesses, the faster you can get your return, the more attractive the system is. So I think this is an extremely innovative way of ensuring quicker and faster access to the courts in a manner that does not strictly comply or conform to the rules of evidence, and so therefore enabling parties to really have their day in court. So I think in a nutshell, and in an almost a non-legalistic manner, that is what we would define a small claim to be.
Thank you, President Theory. I think that's an excellent introduction from which I can even invite our next speaker. I don't want to say too much because I would like her to respond to some of the things that you have said, President Theory. And I'm delighted to introduce our second speaker, who can give more insight on whether the purpose for which this court has actually been met. Acting Registrar of the Small Claims Court, Honorable Stella Kanyiri. Welcome.
Good evening,
Honorable Kanyiri
you can hear
is
me?
a driving force. Yes, we can. We can hear you loud and clear. Honorable Kanyiri is a driving force behind getting this court up and running. And I would like to ask her, do the numbers speak the story that President Theory has laid out?
Okay, thank you, Harry. I think before I respond to your question, let me first off thank you and Swala Nyeti for hosting us to have this good discussion about the small claims court. And thank you particularly for the support that you've given the court. You've been very well engaged in our training sessions with the stakeholders as we roll out the court. And as the president now has said that the main objective of the small claims court is to enhance the access to an expeditious delivery of justice. Because as it has been noted, there was a wide section of the Kenyan populace had been excluded from attaining that justice. Because as you know, majority of Kenyans would not ideally go to court to make a claim or to follow up on a claim below 1 million because of the cost that would be attendant to that and also the time implication. But now we are seeing people who have got claims for 10,000, 20,000, 5,000, 1 million coming to court now because one, they can self-represent, and two, that the court is very cost effective, and three, that they're able to get a judgment on their matters in a timely manner. As you know, the court is under the Small Claims Court Act, the court ideally should hear all matters brought before it within 60 days. Of course, the instances where those timelines have been achieved, and the others, because of one reason or another, they have not been achieved. But by and large, we've tried to ensure that we have kept the time for conclusion of cases within a good time. As per the data obtained by our Directorate of Planning in the month of December, our median time for conclusion of cases was 53 days. At that time, we only had 3 adjudicators in Milimani, 1 was at home. So currently we have 10. So we're hoping to see that the median time for conclusion of cases should be able to go significantly lower. And we are hoping to beat the mark achieved by Singapore which in the last report, the World Bank Ease of Doing Business report had been ranked at number 1, with a median time of concluding or end or enforcing contract at 164 days. So we are hoping to go even lower under the 53-day mark. So I'm also very happy, Harry, as you've said, we're commemorating our 1-year anniversary. I am beyond excited. I'm happy. It's been a long journey, and we're currently in 8 out of 12 counties where we had projected to roll out. We are in Nairobi, Kajiado, Kiambu, Uasin Gishu. We are in Nakuru County, we're in Nyeri County, Machakos, and Makueni. We are hoping to soon move into Mombasa, Kisumu, Kakamega, and Meru by the end of this financial year, by June that is. And we are very happy with the progress. And the numbers do speak for themselves, Harry, as you've asked. As we see, for the Milimani end of the pilot court, we have registered 8,000 cases in our pilot year as of today. And I have been comparing the data between our court and the Milimani Chief Magistrates, the Milimani Commercial Court, because we had projected that we would be able to at least get 30 to 40% of their cases. But what we're seeing from the data is that the cases at the Milimani Commercial Court are not going down. And this is indicative that there is a section of people who would not ideally have gone to court who are now coming to court, because I think they will still do their normal between 12 to 15,000 in a year, and we will do our 8,000 in our first year of operations. So basically, I think the court is achieving its objective. As you know, the underpinning logic for the setting up of the court is that 1, the court is supposed to enhance the access to an expeditious delivery of justice. This we've done because we have tried our very best in our capacity issues notwithstanding to have our matters expeditiously determined. And we are trying to comply with the provisions of Section 34 of the Act, where all matters are heard within 60 days. And at least we try and deliver judgments within 3 days from the last day of conclusion of the matter. Of course, we must understand that the Milimani Small Claims Court is a very busy court. We're registering about 150 cases per day. Even the Milimani Commercial Court does not do that at its peak. So there's a bit of pressure on the part of the adjudicators, but they're doing the best that they can. And we also are meeting our second objective, which is the reduction of cost and time of determining of commercial disputes, which is one of the other rationale for the establishing of the Small Claims Court. As you know, for our 1 year of operation, there was no fee charged on the commercial cases filed. We are yet to obtain a waiver from the ministry for commercial cases. So we shall be introducing the fees chargeable for commercial cases. But for those who've interacted with the court, they know that you cannot pay more than 1,000 shillings at the Small Claims Court. So as long as your claim is below 1 million, we will not charge you. The most amount of court fees that you will pay should be around 1,000 shillings. And lastly, I think, and this one, maybe we need to give it time, is that the court is supposed to reduce the backlog in the mainstream courts. So for the pilot court, this has not been done. What we've seen is that we've seen more people now coming to court. We are now expanding that space for persons who would ideally not go to court, now they're coming to court. So maybe as we move forward, we will see that the Small Claims Court may be able to just get or rather hive off a chunk of the cases that have been going to the mainstream courts. So far, so good. We're happy with the progress, with what we have achieved so far, and I'm happy with what the adjudicators have done. I know there's the issue of capacity, but I'm sure we can discuss this as we move on with the discussion.
All right, thank you very much, Honorable Kanyiri. And I have to say those numbers are very impressive. And I want to bring in President Theori to speak about one specific number. You've talked about essentially the caseload in Nairobi being doubled over the past year. President Theori, have the lawyers been able to absorb this increased number of cases? And what opportunities, if any, exists in the profession?
I think the good thing about the current filing system is that we can be able to support some of the sentiments that are made with the data that then gives it the credibility that it deserves. And I think from the last time I had an interaction with the court, I can say that about 80 to 90% of the cases that have been filed at the small claims court have been filed by advocates. And so I think by and large, then that supports the presumption that most of those cases have been handled or have been filed by advocates. Of course, we recognize that as this court picks up, there is a probability of very industrious Kenyans exploiting some of the provisions of the Act. But I'm sure that we would be having a discussion with the court so that we can keep a close eye on that to ensure that we do not allow masqueraders to use the provisions in the law that allow an authorized representative to file the cases. So I think we can safely say that the high volumes at the small claims court and the high and extremely ambitious turnaround time, which has been met in most of those instances, has resulted in a direct benefit to majority of our members. And I think that as this court is rolled out across the country, we expect the scenario within Nairobi to replay itself. But of course, it also has other consequences. And I think that for me, my greatest concern is actually the question of capacity and whether we can be able to maintain and sustain this momentum going forward. But so far, so good.
All right. I think that's a very positive note to end on. So far, so good. We hope to maintain the momentum. And I'll just come back to Honorable Kanyiri, because you said you're excited about celebrating the 1-year anniversary. Is there anything that you have planned for tomorrow for the actual anniversary?
So at the station level, at the Milimani Small Claims Court, which has been in operation for longer than the other courts, we shall be holding an open day where we intend to host our court users. They can come to the court there and make general inquiries about our operations. They can receive and or pick pending decrees, warrants, or proceedings, or whatever. We just want the court, the members, our court users, to come to court and see what exactly is happening in our registries, so that we do not offer our justice, our services in darkness. So that they also appreciate when we tell them maybe you need to wait 7 or 14 days for a decree. This is the process that preparation of that decree will take. So that is what we're having for tomorrow at the Milimani Small Claims.
Thank you very much. So you've had it. If you have to find out the status of your case, or you just want to know more information about the Small Claims Court and you're in Nairobi, you can attend the open day tomorrow at Milimani Small Claims Court. I want to now get a bit more into the details and speak to some of the people who would be using the court. And I want to start with Robert Yahweh. Robert, are you there?
Yes, I am.
All right. Now, Robert Yahweh is an angel investor and a serial entrepreneur dealing in cutting-edge industries. And one of the things that Honorable Kanyiri mentioned was that the Small Claims Court in Kenya is trying to beat Singapore in the ranking for the World Bank on ease of doing business. And as an angel investor, Robert, I want to ask you, in the past 1 year, would you say that it has become easier to do business in Kenya because of the Small Claims Court?
I wouldn't be able to say much on that, because I think where our problem really starts off with is most people don't bring in the law when they start off their journey, especially with startups and the rest. It's only when things go wrong that they all start trying to get legal representation. So I think for many of them, they still haven't gotten to the point where they appreciate that they need to get their acts together before so that some of these issues don't become litigious.
And when you speak of some of these issues, could you maybe explain some of the things that you have experienced with startups and starting new businesses and legal disputes?
One is partnership agreements or founder agreements. They don't agree right from the start on basically what's the ownership structure and the rest, and they only start fighting about it either when there's an investor coming in or when somebody starts feeling that they've put in too much time into the business.
Okay, as you mentioned that, I have seen that there's a lot of international organizations which will be setting up shops soon in Kenya, including Microsoft. I believe Google is coming in to set up an innovation center.
Yeah.
And when it comes to these big organizations and the challenges you have mentioned regarding entering into agreements, do you think the small claims court can play any role in ensuring that the ease of doing business is easier for both the investors and the people who are being invested in?
Generally, ease of doing business in Kenya has been very good for the last couple of years. For example, you're talking about I can register my company online. Most of our taxes and the rest, all our filing are all electronic. I believe we need to accept that we've come a long way. But when it comes to those larger corporations and as well as the VCs, most of them, don't forget, insist that the companies must be registered in Delaware. So in other words, they don't seem to have much faith in us being able to handle some of those complex cases. So I think it's more to maybe the president of the LSK and the rest of you in the legal fraternity to come out really and try and explain to us why is it that most of these foreign investors don't think it is safe for them to have issues resolved locally and insist that they have to get done in Delaware.
Okay, I think that's a good point to bring in our next speaker. Pamba Oma, are you there? Pamba?
Yes, I am, Hari.
Okay, Pamba is an advocate of the High Court and he specializes in dispute resolution for commercial transactions. And the things that Robert has mentioned seem to suggest that there are some commercial transactions which are too complex for the small claims court to handle. Has that been your experience, and what do you think can be done about it?
Well, I won't say that there are certain transactions that are pretty complex for the court, but just to point out that when you look at the mandate of this court, and it's leaning towards the commercial transactions, is in respect of two contracts, and that is the one for sale and supply of goods, and perhaps the other one is that of a contract basically relating to money held or received by another party. So the baseline for these two contracts, regardless of the amount of goods that are involved and the money that is in question, I believe that the principles around these contracts are similar, and our adjudicators have, with time, proved that they can handle complex contracts and contracts of such nature, which will be similar to any other contracts involving huge amounts of money and, huge amounts of goods being sold between parties.
Okay, so Pamba seems to believe that there is sufficient capacity among the courts to handle all types of contractual disputes. And I'll just come back to you, Robert, and ask, if you had a contractual dispute today, would you, as an angel investor, be willing to approach this court to resolve it? And if Yes or no? Why?
One, I think what he said is that it's mainly for supply of goods. He didn't mention whether it includes goods and services. Can you clarify that?
Yes, it does, Robert. Supply of goods and services.
Okay, thanks. Because if it was only goods, then it would be excluded. But also the other thing is that the limit is very low. 1 million is a bit on the low end of whatever disputes would most likely arise, would most likely be for much higher amounts. So which therefore means most of us would not be able to use the small claims court.
Are you then suggesting that perhaps we should either replicate the same procedures of the small claims court to the other courts, or are you asking us to increase the limit of which this court can adjudicate?
I think the limit should, because to me, I'm thinking 1 million is a little too low. You're really looking, most of what will happen here will be domestic issues, domestic labor issues and the like, that will end up filling and clogging the court. So with time, either we'll need to create an intermediary, maybe one that does between 1 million, above 1 million to maybe 20 million, because then that will be a different kind of, that will be more likely to be where we shall be playing.
Okay, and I'll just come back to Pamba. You've heard what Robert has said. As an advocate, you know that there is a court which has a jurisdiction to handle these matters between 1 million and 20 million. How would you respond to his suggestions?
Thank you. I believe this court is fairly a year old. We are yet to, subject to the statistics that have been given by the registrar and the president to assess its viability. And just to disclose, the Act actually allows the Chief Justice to increase the pecuniary jurisdiction. That means the limits to which this court can handle the disputes. So as Robert suggests, that is a conversation that will be picked or can be advanced by stakeholders of this court with time, so as to assess the viability of us, increasing the limit to whatever amount that we would deem to be, a good amount, or rather that a limit that will help us achieve the objectives of this court. So to me, it is a conversation that we can carry on going forward in the next years and have the Chief Justice exercise that power to, increase the limit of the court, the court's jurisdiction.
Okay, I like that. So there's an opportunity to see whether this court can increase its limit and possibly handle some of the other cases that Robert says he can't handle right now. I want to
Harry, just before, if you don't mind.
Yes, sure, Robert.
Okay. In our space, what will likely be a bigger issue will be things like IP. Mm-hmm. Is that an issue that the small claims court will be able to address? Or do we have to go back now to the commercial court?
I think, Pamba, you can take that one.
Harry?
So on IP, it will depend on how, what aspects of the intellectual property are being brought before court. Say if it's infringement, then from where I sit, it is a contract that the court cannot handle. Like I pointed out, the court, other than, liability in tort and damage to property and personal injuries, can only handle 2 types of contracts. That is the one for sale of goods and services and the one for money received or held. So if the aspects of IP that Robert is alluding to are such that there is a service that is being rendered by a party to another, then that court, the dispute arising from such contract can squarely fall before this court, and provided it's within the limits. But if it's the other aspects of IP like infringement, then that will have to go to the commercial court for their determination. Because of course, again, when you look at infringement, there is a possibility that even the amount that might be at stake will be way higher than 1 million shillings.
Okay, thanks a lot.
All right. So it seems that there are still some
Harry,
questions to answer. Yes, please.
If I may
Honorable
respond
Kanyiri.
to what Robert had raised, I think if we look at the rationale for the creation of the court, it was essentially to create a system where commercial disputes involving small amounts of money are quickly adjudicated over, so that they're determined in a timely manner. Because if we introduce complex issues again in the small claims court, given the strict timelines of 60 days, then the court will not be able to handle those complex legal issues. And if you look at it, as it is now, the small claims court and the magistrates court are currently exercising concurrent jurisdiction, meaning someone can choose, my matter is a bit complex, I'll file at the magistrates court, or this one is a simple matter below 1 million, or a value below 1 million, I will file at the small claims court. And if you look at other jurisdictions, I think like Uganda, their limit is around 10 million Uganda shillings. That should be around 100,000 plus, if I'm not wrong. So most countries who have a small claims court, the pecuniary jurisdiction is actually way much lower than what we have in Kenya. I'd like to think Kenya's pecuniary jurisdiction is among the highest at 1 million. And if you look at it, it was important that we set up this court to protect the SMEs because of the existing power imbalance between the big corporates and the small businesses. Ideally, the small businesses will not be able to have money to spare to come and pay 70,000 shillings, 100,000 shillings to file a suit, right? But the big companies can be able to pay the filing fees applicable and have the matters handled at the small claims court. And if you look at it from our data, very many small businesses, the mama mbogas are not coming to court to come and enforce their contracts at the court. So even as we seek to enhance the jurisdiction, there could be that risk of burdening the court with very complex legal issues, unless if then we extend the timelines.
Harry, if you don't mind, I think she's brought a very interesting concern. If you're talking SMEs, yes, I still feel 1 million is then very low, because if I was an SME and, for example, I've got a contract to supply sugar to a miller, chances are the amount will be above 1 million. So doesn't it seem like you need to start increasing that limit very soon? And maybe that's why the cases are not coming down from the main commercial court.
I think you raise an interesting point, and I will bring in a speaker later to address exactly what you have said, because we do have someone who is a specialist in the SMEs. But I do want to touch on something that Honorable Kanyiri said. Essentially, the court is making a trade-off. If you want matters resolved in a quick time, then the nature of matters cannot be very complex. So it seems there's a trade-off, and it's trending towards resolving matters in a faster time and not having very complex matters, which is a discussion we can still continue having. But I would like to look at the other aspect of the court outside commercial transactions. And this is with relation to the civil wrongs and how they can be resolved through this court. And I want to bring in another advocate, Kate Cahill, who is a frequent user of the court, handling dozens of cases every day. Kate, are you there? Okay. Welcome, Kate. Now, Kate, I want to look at a different perspective. A lot of nice things have been said about the court, the numbers the court has been able to handle, and even what they have been able to resolve. But a common complaint I have heard is that lawyers are the ones who are preventing this court from reaching its full potential. Would you agree? Kate, we can't hear you. Not yet. Try again. Okay. Go ahead and see if we can hear you. Unfortunately, we still can't hear you. Okay. What we'll do, we'll ask our next speaker and we'll come back to Kate. Our next speaker is Gashau Patrick. Gashau, are you there?
Yes, I am.
Excellent. Welcome, Gashau. Now, for those who've listened to the Swalanyeti podcast, Gashau will be very familiar. He's a layman half of Swalanyeti, but he's also much more. He's a serial entrepreneur with interests in tourism, farming, and restaurants. Gashau, I want to ask you, as a layman, what can you say about this court?
I I deal with two types of people currently, and I run a cloud kitchen, something like Kune. You might have heard of Kune Food. Those guys are copying us. So what the two types of people I deal with every day are people in Milimani and Westlands who are ordering meals, and then the courier, border people who take those meals to them. And to your question, the people, I feel generally in Kenya, there are people who feel they can get justice easily. They know their rights, so to speak. If a person can complain about a burger they have eaten, that is a person who knows their right, and they want it refunded and their money back. On the other hand, the border people sort of feel they have no access to justice. That's my honest, what I feel when let's say I sent a wrong meal to a customer, and even the customer refused to pay the border person, even when the border person's job was only to deliver the food. And therefore, it could be an issue of perception, but generally you feel like these people feel like there's no other way out when they are aggrieved.
So you saying the borders feel like there's no way out when there's aggrieved. How does that relate to the small claims court?
Because I feel if two things that come into mind. One is most border riders do not own the bikes. They usually have a contract, usually verbal, with the owner, and they pay 400 shillings a day. Whenever there is a dispute there, people don't go to court. And I feel small claims court would be ideal to handle such issues. Secondly, when a border rider might have been, I doubt small claims court deals with accidents. However, if it does, if a person has had an issue, a traffic road accident or incident, has their papers, what I tend to see is border riders just get up and run away, even when oftentimes they are right. Especially if a person is doing deliveries for third party, Glovo, Uber, Bolt, they must have the papers. So the tendency is for them to run away. And I feel if they knew they could get justice, they should be taking these claims to small claims court.
Okay, thanks, Gashau. You've said something that I would really like Kate to respond to. Kate, are you able now to switch on your mic and see if we can hear you? If you can hear us, Kate. Gashau seemed not to be sure whether the small claims court can handle accidents of border riders. Perhaps you can start by responding to that before I ask you your question. Oh no, Kate, we still can't hear you. Okay, I'm going to ask our other resident advocate to support Kate on this question. Pamba, are you still there?
Yes, Harry.
Okay, so you've heard what Gashau has said. How would you respond to that?
I have gotten his sentiments, and he's mainly concerned about the ability of, or rather the ability of this court to handle the claims from what he calls his usual border riders. And this is an accessible court, first of all. To begin with, it's an accessible court. How to bring claims before this court is pretty simplified. It's a very simplified way of there is a simplified way of approaching the court. All perhaps that should be done is a little bit more of some sensitization to the common mwananchi on how to approach the court. And when the registrar talks about the rationale of this court and why it was set up, the same is embodied in its rules and the act to an extent that the court is even allowed to use, indigenous languages in its proceedings. So whoever is out there and has been involved in an accident, regardless of their stature and the nature of the accident, provided there is personal injury suffered or there is loss to their property, and in this case, it will be their motorbike, they can approach this court through the simplified forms. They only need to bring a few information and documents, and the court will certainly entertain them. And just to stress that there is some need, from my assessment, there is some need for more sensitization about the court and its processes. So I'm happy even that tomorrow we have an open day, which is open to the public. And you may encourage some of the people to pass by. They can get great insights on the court. Thank you.
Harry, I'm back.
Gashau.
Harry,
Oh,
can
great,
you hear me
Kate.
now? Okay, thank
Yes, we
you.
can hear you.
All right.
Okay, Kate. So Pamba has helped you out answering the question of whether the court can handle personal injury cases.
Yes.
And I will come back to Gashau to ask him if he's satisfied with that answer. But Kate, I wanted you to answer my initial question. There are several complaints that lawyers are the ones who are preventing this court from reaching its full potential. Would you agree?
I wouldn't agree. First, I would like to say that I'm Kate Kahio, practicing in the name and style of Kiruki and Kaika. Basic introduction. I'm also in the BBC of Small Claims Court, the Nairobi branch. I've had the privilege of practicing. I mainly deal with insurance matters, material damage. I defend personal injury. So indeed, yes, Gashau, the Small Claims Court can handle personal injury claims. Those include soft injuries and fractures. And coming to your question, no, I don't think advocates are frustrating the processes in the Small Claims Court. I think it's more of a challenge of on how the bench and the bar is. The bench and the bar is interacting with each other. So the main challenge that we can say in the Small Claims Court is a very major challenge of service. You get that some advocates don't get time to serve, and if you serve, you're also told to send M-Pesa. So that one is one major challenge. You're expected to serve within a few days, which is okay, because once you knew that you've come to the Small Claims Court and the limited time limitation of 60 days, you have to serve within limited time, meaning within 7 days or even 3 days if it's possible, depending on the mentioned date. So service has been a problem. Now, I think that is the major problem, and unless you have something specific in mind, Harry, that you want me to address. So service, you having not served within time, makes the adjudicators very, what can I say? They dismiss your matter. It's a basis of dismissal, very easy dismissal. So no, advocates are actually trying to help the court. So I disagree. I disagree with that statement.
Kate, if I understand you correctly, you're saying that the challenge you have experienced with the court is some of the processes that the court requires you to undertake. But from what I've heard you say, it seems those processes will just ensure a fair trial, making sure that the person who is being accused or who is being complained against has a reasonable opportunity to respond to the complaints. Wouldn't you agree that it's only fair?
Yeah, it's only fair. That's why I'm saying you need to be given time to serve. But what the advocates are really not happy about, the bench, the bar, is that when it comes to serving people, the respondent, sometimes you fail to even, for example, serve a mention notice, and you have to put in a certificate of service. You come to court to say, I've already served the pleadings as it is. I have not served the mention notice for one reason or another. You're in court. Your matter will be dismissed. So is that a reason why you want to now take the blame to the bar and, start saying that they're frustrating? No, I don't think so. I think there's a problem with the relationship, and being in the bench, you have to understand how the bar works and the challenges of service, and also the challenges of even the respondent filing a response in the courts. So these are things that I think we should discuss. We should discuss as bar and bench, but they're not anything that limits access to justice. This court is working so well, and I recommend it for the same. Honorable Kanyeri and team have done a very good job in terms of conclusion of matters. I can attest to the fact that I've concluded, as a firm, we have concluded so many matters over 100 actually, over 100. Well, some have been dismissed, but the court is working well for civil litigation. Yes.
Thank you very much, Kate. And I think you've ended on a good note that there is access to justice that has been experienced. And I want to come back to Gashao, because Gashao, you've had the opportunity of speaking you've had the opportunity of hearing two lawyers speak back to back. Do you feel more confident that you or those borders that you work with can access this justice based on what you have had these two lawyers say?
I think the answer is both yes and no. I think there is goodwill, that's for a fact. However, as long as there is no sensitization and people feel like justice is a far removed thing that they easily cannot get, then I'm afraid most guys resort into mob justice or to the abhorrent things they did on Wangari Maathai Road. The more people feel they are not able to get justice, the more they are going to take matters into their own hands. And I more and more feel like border people feel like they are always on the losing, the short side of the stick, like wanaonewa, that's what they feel. Even if they themselves might be liable for the laws they break, the tendency is just to take matters into their own hands. So yes and no. There is goodwill for sure, but maybe we need to educate people a bit more.
Okay, you bring in an important aspect of education. And I think our next speaker will be very timely. I'd like to invite Mr. Justus Munyithia, who can be our next speaker. Mr. Munyithia, are you there?
Yes, a really good afternoon, good evening, and good evening, President
to you.
Avi and the Honorable Stella. Thank you very much for
Karibu
inviting
sana,
me.
Mwalimu.
Asante sana.
Mr. Munyithia is a principal lecturer at Kenya School of Law. the institution which is responsible for training advocates. And therefore, he holds a special place in education and ensuring that these concepts are able to dilute through the advocates and down to the public. Based on what you've heard, do you believe KSL can play any role in the education and sensitization required?
Thank you. Thank you very much, Jerry. Let me just correct that I meant President Eric Theory. Eric, no problem if I called you Harry. I know Eric Theory, my very good friend, and congratulations once more where you are. Harry, congratulations again for having Swahili Nyeti. Initially, I thought you were telling me to come and speak in Swahili, which I would have tried, because the small claims court should use Swahili as the first language because of the nature of claims we have. Now, let me say that as a lecturer at the Kenya School of Law, I'm privileged to teach trial advocacy. And one of the topics we always speak about is the forums where parties or advocates can practice the art of advocacy. So the Kenya School of Law plays a key role in sensitizing stakeholders, because every year we normally have outreach programs in prisons, in communities, and currently in collaboration with Kituo cha Sheria, Strathmore Law School, we have signed some MOUs to start running legal aid. The School of Law then would use the students to sensitize the members of public about these courts, which have come to deal with disputes below 1 million, and where we know majority of quite a number of Kenyans have not been able to go to court because, one, they did not understand the legals of going to court, the expense of getting a lawyer. But now the small claims court have come to assist that. So the School of Law will be one forum in which, during our legal aid program, we can be able to sensitize the public about the system, the procedure, and where these small claims court are. Thank you.
Thank you very much. And you bring in an interesting aspect that we should spend more time speaking in Swahili in this court. And I can see personally for me, that would be an area of improvement I would need to work on.
Yeah.
But more than that, you have talked about sensitization programs that can be run by the School of Law. But I also want to ask you, with advocates themselves, are there any gaps in the training that you have identified from this discussion and you think the KSL could fill?
Yes, I think because the small claims court, you remember the act came into effect in 2016, but they were never set up until the year last year, I think. This is the first 1 year when we are seeing how the court operates. So one of the gaps that we may need in terms of training, and the School of Law can do that through continuing professional development, which is run by the School of Law in collaboration with Law Society. We can host CPD programs, workshops, and webinars to let advocates understand the rules and the procedure of the small claims court, and to see the purpose as to why the small claims court was set. When you look at the whole purpose of the small claims court, and from what Stella Kanyiri has said and others, the small claims court was set up to first try and reduce backlog for some cases which would stay in the other magistrate for so long. Two, provide access to justice for the mwananchi. I don't want to use the word hustler, which has been used, but you'll find that quite a number of people are doing businesses which bring income between 10 shillings to 1 million. And sometimes when they cannot afford the service of a lawyer, they end up then not going to court and getting discouraged. But if the small claims court, members of the legal society, of the law society of Kenya are empowered, where a client cannot afford you to go to court, you can charge the client with just preparing the pleadings, then also empowering the client to be self-represented. And for the advocates, it is another opportunity where the School of Law can train them on mediation and arbitration or negotiation, which I have seen is encouraged in small claims court. The School of Law runs those CPD programs for purposes of improving the skills of advocates who are in practice. The other thing which is important is that drafting and legal writing is a subject that is taught at the School of Law. one of the core things that is required in a small claims court is to ensure that you can dispose a case by way of documents only. So that if then advocates come to the School of Law for professional training, they will be trained on how to add evidence, how to properly paginate and write proper pleadings, so that on the outset, an adjudicator looking at the documents, even though they are not advocates or lawyers, they can be able to dispose the case, crystallize the issue. And this is the art in which the School of Law comes in. There is a whole course on legal writing and drafting, and there's a whole course on what I've called trial and trial preparation in a small claims court.
All right, thank you very much for those insights. And I really look forward to seeing the Kenya School of Law start some of the programs that you have mentioned. I do want to pick up on a thread that you started. You mentioned that there are a group of people who could greatly benefit from this court. You call them the hustlers. I want to also believe that they fall within the category of SMEs. And Honorable Kanyiri earlier had mentioned that SMEs could be a big part of the users for this court. And we do have someone who deals with SMEs regularly that I would like to come in and address some of these things that have been raised about the court and SMEs. Annabelle, are you there?
Yes, Harry, I'm here. I hope you can hear me.
Yes, we can. Yeah. Annabelle Wanjiko runs the SME Space, a platform for information sharing among SMEs, among other things. It sounds like SMEs could be primary beneficiaries of the small claims court. Where do you come in?
Thank you, Harry, and thank you for organizing this forum. I think it's a very important one, especially for education purposes of what is happening within this space. Now, I've had the word SMEs being thrown here and there. I want to first clarify, correct the use of the word SMEs. By its nature, SMEs is small and medium-sized enterprises. Now, there's another category which is being spoken of that probably is not covered under SMEs per se, and that's the micro. So sometimes you hear micro MSMEs as opposed to just SMEs. SMEs, by definition, usually are organizations with a turnover of about 5 million per annum, which comes to roughly, I think, 400,000 per month. If you listen to the discussions, a lot of the organizations which are being referred to here are more of the M as opposed to SMEs. They're more of the micro. And from there, I can clearly see that for micros, this is godsend. This is one of the things that will really, really help them be able to run businesses in an effective way, because there's matters which they would have liked to take to court, but because of lack of finances or lack of the time to be able to do it, or even mistrust of the court, because let's be honest, there's a lot of mistrust in line with, will it be properly heard? Will someone, there's all those thoughts around what happens in court, because I guess it's also because of the complexity of the processes. So definitely micro will be served very well by this court. For now, let's come to the S and M's, the SM within the SMEs discussion. And I think that's what Robert had alluded to earlier. There's S, which probably would have a lot of cases which can be resolved within the court. I think S goes all the way to about 20 million an annum, or around that much. So there's cases which will definitely be resolved within the court. But there's those which they might find might be above the 1 million ceiling, and so might have to go again to the other courts to resolve it. And M as well, you might find that a lot of the cases they might go above the 1 million ceiling. So back to your question, will this help the SMEs? It will help the MS a lot more than probably the SM bit of the SMEs, which is not a bad thing. It's not a bad thing, but it might not, as I think has been alluded to earlier, might not reduce the jam in the courts as they are currently, because there's still a gap in terms of meeting the needs of a certain group of businesses within the country. But from what I've heard and the discussions which have been there is that this being the first year, it's something which is growing. I've seen that on the chart that it started at 200,000 and it's grown to 1 million. And probably with months, most structures are put in place, it might be able to also capture the needs of the S&M more. So yes and no, I do definitely believe this is an important initiative for the small businesses, especially the micro and the small ones. There's still space for more to be done to support these businesses, and I hope it will be within the same process, making it in a way that it's fast. It's something which can be resolved in a very fast manner, because that's one of the things that businesses lack. Resolving issue in a very fast manner, very transparent manner, which I'm really excited to hear about. So I think in answer to your question, that's what I would say for the SME sector or the MSME sector.
Okay. I think you have improved our knowledge of how to define businesses.
Mm-hmm.
So we have really been referring to the MSMEs, the micro and
micro,
small
yes. micro
businesses.
Mm-hmm. Mm-hmm.
And these are the businesses you say would mostly benefit from the court, which provides remedies of under 1 million shillings.
Mainly, you'd find that those are the ones who are not even in the court at all and are now coming to the court. So definitely it will improve for that particular area, that particular sector.
I want to bring Mwalimu back into the discussion. He had talked about mediation as being one area in which the Small Claims Court encourages and which he believes the Kenya School of Law could play a role in.
Yes.
Mwalimu, having heard the sentiments of Annabelle regarding the MSMEs, do you think then that they would be better served outside the court, or do you still think they should access the court?
Well, thank you very much, Ari, for that question. I think that because I've seen the way directions are required, immediately a matter is filed, there must be a mention date. You don't just file and leave the matter like that. So mediation will be critical in the sense that if the parties now file a claim, they get the option to negotiate or mediate and record the settlement before the court. It becomes much easier because the court itself will be able to monitor the steps the parties are taking. Sometimes when you tell them to just negotiate outside, some parties take advantage and start taking a party around. And the party who is ignorant might be taken so around that the time lapses. And remember, we have timelines within which to file a suit. So what I would encourage is, yes, parties can discuss it and come and record a settlement. Or once parties file the matter, the judge or the adjudicator can point out to the parties that there are avenues in which instead of going through the whole way in terms of a hearing for the period of 15 days, please look at the following issues and see which you can settle and what we can settle, bring it to us to dispose. That becomes easy. One thing I like about the Small Claims Court is that most people in this category of business don't write very complicated contracts. It's a very simple thing. I have an underwear shop. I supply to you cotton. We agreed to pay this day. You paid a deposit. The other one you have not paid. You have been giving me false promises. Or business collapsed during COVID-19. I was not able to pay. Now it has revived. That's the nature of some of these disputes between 0 to around 1 million shillings. And therefore, I really, really encourage that mediation becomes part of the Small Claims Court. It should be like a tool that immediately parties come, and now that you're having this open week, to tell them there's an avenue in which Even when the claim has been filed, you don't have to wait for 50 days. You can settle it on the 10th day and get your check home.
Thank you very much, Mwalimu. I can see a lot of questions coming in on the issues you've raised, and I would like to circle back later to some of those processes you think could be improved in the small claims court.
Okay.
But for the moment, I want to shift gear and talk to two groups who seem to be perennially following up bad debtors. To begin with, I have Rosie Rana, Managing Director of Dorman's Coffee. Hello, Rosie.
Hello, Harry.
Now, Dorman's is in the manufacturing industry. And Rosie, we've recently seen manufacturers being on the short end of the stick when it comes to following up debt, especially with the collapse of retailers. Do you believe the small claims court can alleviate some of the challenges that manufacturers face, especially with regard to credit and bad debtors?
Thank you, Harry. I think it's really a promising initiative to have a court which handles these small claims so quickly, so swiftly, because sadly, within our retailers, we had formed what you would call a punitive culture. It was almost habitual, if you like. I mean, you talked about the collapse of retailers, but even prior to such collapse, it had become a habit to just build debt even when they knew they couldn't pay for the goods. So it was almost like a scheme or a plan, I'm sorry to say, to just accumulate it. So has this helped? Absolutely, in people realizing that this shouldn't be allowed to continue. It's been fantastic to see. And in fact, it's given us some faith, if you like, in the justice system, because I'm sorry to say, in many ways, we had lost it. We didn't have any because you just kind of keep going through cycles. I have said to you before, it was almost something that retailers know they can then file for, they can basically file for either bankruptcy or protection, and then you can't touch them. I personally, in fact, I want to pick on something that was said by your president earlier, the president of the Law Society of Kenya. Yes, it's given us hope, but let us not just hope. Let us make sure that we can sustain and maintain this momentum. A, that, but B, let us also, in fact, if we are talking about the ease of doing business, then we really must make sure beyond this, we are able to replicate these processes. I mean, I understand and appreciate from the discussions today that the small claims court is looking at simple cases less than $1 million. Fantastic. But there are also similar cases, very simple. The only difference is that the value is higher. Goods have been supplied, services have been supplied. There's no dispute about the owings or the outstanding. So there's no reason why the other courts should take so long. Let them borrow a leaf from the small claims court. Perhaps there should be a separation of some processes or some clarification where a case is simple, straightforward. Why should it take months? And why should people have to find it complicated or pay tons of money and have it drag? So the small claims court has been speedy. How can we replicate that going forward? So it's a blessing to manufacturers, but does it resolve things? $1 million kind of limits you to very small claims in many ways for manufacturers, but it's a start. So yeah, thank you, Harry.
Okay, Rosie. So from what I understand, the small claims court is a great template which other courts can adopt. And I think that challenge is to all those in the legal and judicial sector. I would like to also hear from another category. This is someone who is in the creatives industry. Mike, are you there?
I am, Harry. How are you?
I'm good. Now, Mike Mugai is a creative director at Genesis Design Factory. And Mike, I see creatives constantly complaining on social media about not being paid for services delivered. Do you believe the Small Claims Court offers any relief to this very important industry?
It's hilarious that Honorable Stella's camera has just gone on when she had creatives. Maybe that's the bigger part of the people who appear before her. For me, the Small Claims Court is more like a rungu than it is anything else. It offers hope and it also deters people. The possibility of facing a judge in a very short time will actually discourage those who go in with ill intentions. Our industry is plagued with people who actually understand that these are young people who have an ability they have cultivated, not through education all the time, but sometimes through practice. And they're able to take advantage of them because these young guys don't understand that I need a contract. And if I'm able to get a contract and put it in place, I don't have the resources to actually chase after the amount. And one of the things is that what if what I'm claiming is actually less than what I'd pay a lawyer? My fee is 60,000 shillings for photography, and my lawyer is asking for 150,000. I would write that off traditionally. The process we have is one where you should have an LPO or a contract, but most guys don't understand that. There's different categories or tiers of creatives. I started in that place and grew to the place where we are an advertising agency and most of our work is beyond $1 million. So the Small Claim Court kind of allows us to start thinking creatively and saying, hey, if you want to pay me 10 million, should I break it into 10 contracts of 1 million, just in case, so I can start challenging individual millions, as opposed to going through the whole process? That is tempting, but I would say that data from the Small Claims Court should actually allow the court to understand that most of the cases in creative industry come because maybe the actual contract wasn't done well, and then educate industry. Someone has spoken about educating lawyers. I think lawyers have been in class too long. Let's just educate the public and figure out a way for some of these matters to be sensitized in advance. So if I go through the process properly, then there's no need for me to go later on. And the Small Claims Court actually succeeds not by taking too many cases, but by actually creating a scenario where cases stop coming because these young guys have started understanding how to go about it and what to do.
So, Mike, I think some of the lawyers might respond to your creative ways of splitting claims, but I do want to bring Rosie back and ask something that Mike has alluded to. Mike says that creatives need to be sensitized. Do you think manufacturers would be in the same boat? Do they know about the Small Claims Court? And if not, what do you think can be done about that?
What Mike says, I agree with completely. I don't think there's been enough. I don't know whether a court should do any publicity, but I don't think there is enough awareness. This, as I said, is a fantastic and promising initiative because manufacturers as a whole generally don't have their own avenue or their own shops or their own, a channel to sell their goods directly. I mean, nowadays there's a bit of the online platform, but in most cases, they would use middlemen to sell their goods. It's a constant battle because, as I said, it's a punitive culture. Debts are outstanding. So I don't think that many people know about it. I learned of it thanks to you and because I have a relationship with you and we've worked together in the past. I'm not sure. And after that, obviously, once you know something, you tend to see it around or you see snippets of whether it's headlines and the like. But I'm not sure that there's been any forum that I've heard the small claims court being discussed. So I do believe there is need for more awareness. On the other hand, you say you have so many cases. I don't want you to be so overwhelmed that you lose the momentum. So I just hope it can be kept, it can be maintained. And very importantly, send the message down to the public. Let's be honorable citizens. You know, you owe a debt, let's settle it. So there's a bigger case for the country as a whole, you know, supporting the ease of justice. Justice is being served in this court if only the same was, and I repeat, replicate it across the board and make it easier and make it cost effective. Mm-hmm. Thank you.
Okay, thank you very much, Rosie. And I keep hearing the same themes coming up time and time again. The small claims court is doing a fantastic job, but more people need to know about it. So I'm really happy that we're having this discussion today. And right now, I want to open up the floor because we have had a flood of questions coming in, and it would be good for everybody to have a chance to be fully sensitized about what this court can do. And I want to start by inviting President Theuri back because there's some questions of a legal nature which I would love for him to address. Mr. President, are you there?
Yes, I'm still here.
Oh, super. Now, we have questions which have come in regarding what this small claims court can handle. And I'll just like you to address two, which talk about employment matters and rent matters. And you can possibly speak more about those.
Thank you, Harry. First of all, I think before I even respond to those, let me just sort of like comment a little bit about the discussion we've had. And I think this was something which Robert mentioned about the value of 1 million and that perhaps that this value is a lower value for some cadres of SME. I think, to be quite honest, there is a little bit of a misunderstanding of the value of 1 million. And this is one, if you actually just take the 1 million first out of Nairobi, and two, take the 1 million out of the CBD to the informal settlements of Nairobi. And you'd actually realize that this figure of 1 million is an extremely high figure. I think, as the registrar was saying, that it is only Kenya which has such a high figure because, and if you look at even the initial draft, the 2015 draft, I think, was talking about 200,000. So the figure of 1 million is extremely high for any business because it means that it is 1 million out of the business. So I think for any SME, and particularly for SMEs outside the CBD and outside Nairobi, then the figure of 1 million is extremely high. And if they can be afforded an avenue through which they can be able to litigate that and to be able to recover that and bring it into the formal justice system, then we have increased access to justice. The other thing that I want to point out is that this court has very minimal application of the rules of evidence. And this is what makes it attractive. So you think about it, in most instances, especially in informal areas and in areas out of Nairobi, there is an element of a business that is regulated more by trust. So the LPOs that have been mentioned before, properly executed, do not really exist. What exists is just perhaps a receipt that has not been countersigned by both parties, there is no delivery note, or it's a book, maintained by the owner of the business, where every time you order, he puts in the book, he adds in the book, it is not countersigned by the borrower. And when there is a default, if you go to court with that kind of evidence, you will be told that that does not meet the strict rules of evidence. But in the small claims court, such matters can be entertained. Is the evidence credible? And once then the evidence meets those thresholds, hello, can you hear me?
Yes, we can.
All right. So with regard to employment matters, those are outside the jurisdiction of the court, and also cases for rent disputes, those are outside the jurisdiction of the court.
Thank you, Mr. President. Registrar Honorable Kanyiri, are you still there?
Yes, I'm Harry.
Now, a lot of questions have come in regarding the final process in the small claims court judicial process, which is execution. Someone has come in, they've managed to get their case concluded in 53 days. What next? Perhaps you could respond to how the court handles this process.
Okay. Maybe I need to first of all bring them up to speed that the small claims court Milimani has signed a performance management and measurement agreement where we've set timelines for ourselves. And for the post-judgment activities, more so for the warrants and the decrees, we set a timeline for ourselves for 7 days within which a client who requests for a decree or warrant should be able to get them within 14 days. We have tried to attain those timelines. However, the instances where we have exceeded due to challenges of capacity, as you know, Harry, I'm sure maybe you've taken a walk at the registry. We have around 12 clericals and 10 are in court. So only 2 remain behind at the registry to do all the registry work. So I'd like to think that in the circumstances, they have tried their best because we try and sign off as many as we can once they are requested. And in our open day tomorrow, we've tried to process about 200 decrees, which we shall be circulating a list in the various groups for the advocates so that they can come and pick them from the tent or from the service desk, which will be set up at the tent tomorrow.
Thank you very much, Registrar. There's another question which has just come in from Juliet Wanzala, and Juliet asks about the Kakamega law courts. They have seen the things that we are doing in Nairobi and they want to know when Kakamega will be launched.
So what we all need to know is that the rollout of the court has to be sequential, methodical, and has to make sense. And of course, there has to be the issue for the finances to allow the rollout. As I've said, we've rolled out in 8 out of 12 courts. We shall be going to Nakuru next week, and Kakamega should be in the week for between 9th to 16th of May. So we've had challenges in accessing some funding for the rollout, but we've done what we could do with what we have. And I'm sure that by the end of May, we shall have operationalized all the courts that are due for operationalization this financial year.
Thank you, Registrar. And I'm sure Juliet will be happy to hear that small claims court is soon coming to Kakamega. Perhaps we can also go to the advocates and hear their thoughts about the execution process and whether the small claims court is managing to handle the types of cases their clients are bringing to them. Kate, Pamba, anyone who would like to comment on that?
Yes, Harry, I would like to comment. So in terms of execution, as the registrar has correctly pointed out, we have a challenge with the decrease because of the number of matters that are being concluded per day. For example, in a day, we can have like 5 default judgments, maybe in a certain law firm. In a week, that makes it 35. That makes it 25 decrees. So by the time the court itself, and we are not counting the full judgments yet. So by the time the court processes, and due to capacity, we're not able to get the decrease on time. However, there has been a significant improvement, and I think they're also improving on the processes. But what I would like to tell even my fellow councils, whenever you send a decree, that letter requesting for the decree, just help the court by drafting sorry? Oh, can you hear me, Harry?
Yes, we can
I'm
hear
saying,
you.
once you send that to the decree email, there's an email, the system has not yet been automated. Kindly also upload a draft decree to help the court with the process. The decree is calculated using the lower scale currently, because we're yet to get our own arrow for the small claims court. So you can assist the court by using the lower scale of the arrow, the current arrow. You upload it and then you can follow up. Normally, it's not supposed to take more than 7 days. I've not had a decree that has taken more than 7 days on our part currently, but when the court started, it was a bit slower. So there's a great improvement.
All right. Thank you very much, Kate.
Harry,
and I
if
invite
may
any other
please?
speaker. Yes, please come in.
Yes, as we had discussed earlier during our training which you attended, our vision as a small claims court is to have an end-to-end automation of process. Because where we drop the ball is that there are some processes that are on the e-filing system. Then once you get to the post-judgment activities, you now go to the manual system and the email, which is a bit hectic, where you have like 100 emails coming in or more in a day for one person to process. So what we're looking forward to maybe in the coming months is that we have a system where we automate the system from filing to conclusion, so that clients can be able to follow their requests on the system, on the e-filing system, without making phone calls or to the registry or sending emails. I think that would be able to make our processes more efficient. And that will also deal with the issue of the post-judgment activities, which have been somewhat inefficient or slow, to say so.
That's very exciting news to hear,
Also,
because I
Harry,
believe post-judgment is where many people have faced challenges. Is that what you wanted to say, Kate?
yes, that's what I wanted to say. And also to add, I think that I saw a question that was asking about execution. Execution, yes, we're using the civil procedure rules. I wanted to also add on that for the person who has asked. So once you get a default judgment, kindly issue the 10 days notice before you proceed with your execution, extract the warrants of attachment, and all that process in the civil procedure rules.
Thank you very much, Kate. I do want to hear from the non-lawyers, because when we start speaking as lawyers, we can get lost in the jargon of decrees and execution and the rest. And I'll bring in Gashao if he's still there. Are you there, Gashao? Or any other person. From what you have heard today, especially from the lawyers, do you feel like this court is accessible to you without a lawyer? Rosie, I see you there. Would you like to respond?
Well, you've really opened my mind to the possibility. I hadn't even considered the possibility of going there directly without a lawyer, but it's good to know that that possibility exists. Seeing the speed with which my lawyer, who is Mr. Harry Karanja, has been filing the cases, I'm not sure I would have a need to go there myself. I think we all have certain expertise in what we do. But I guess if push came to shove, if the possibility was there, it seems straightforward. So the answer is why not if the need was really there. But I'm very happy with the services I'm currently getting, so I don't need to do that. Thank you.
Well, I'm very happy to hear that too. I believe the other thing that we said we'd circle back to is the issue of mediation. Mwalimu Justus had raised an issue about the processes of the small claims court and whether mediation could be encouraged from the very beginning and whether it could improve the experience of the court to the people looking for access to justice. And I want to throw this question to the registrar because processes really fall within your ambit. Do you think that that's something which would enhance access to justice?
Yes, Harry, by all means, yes. If you look at the Chief Justice's vision, she has outlined mediation, or rather ADR, the small claims court, and AJS as well, some of the other doorways through which Kenyans can be able to access justice in our court. So the dilemma between the small claims court and mediation is that we have conflicting timelines. Whereas cases at the small claims court should be heard and concluded within 60 days, through mediation, they have a timeline for around, is it 90 days? So what happens where parties appear before a court and then you refer the matter for mediation, it might actually take longer than what it would have taken at the small claims court. If you look at the Small Claims Court Act, the court is somewhat different from the magistrate's court in that the court can somewhat adopt an inquisitorial approach, right? So the court is not as adversarial as the mainstream court. The court can make inquiries and can urge parties to consent where need be. So I think the adjudicators need to be trained on mediation so that even as the adjudicator of matters, there are those matters where they can easily mediate over without having to refer those matters for mediation because of the conflicting timelines. But I think mediation is also a good avenue. And we have, in all of our courts, we have set up ADR registers so that where parties, with the consent of parties, they want to refer the matters for ADR, the matter then should be referred. But I think key should be training the adjudicators on ADR and mediation so that they're able to handle these matters when they appear before them.
Thank you, Registrar. And from what I understand, the court is not trying to punish people. It is just trying to ensure there's access to justice. And one of the ways is through alternative dispute resolution mechanisms, which you have referred to. The questions are still coming in, and this conversation is not going to end today. But unfortunately, we have come to the end of our time for tonight's session. I do want to encourage everybody to continue asking questions.
Before you close, there's something I wanted to say. You allow me?
Yes, Mwalimu.
Yes.
Karibu.
And I want to join hands with our registrar, Stella, today, even if it's go to the OPD. When it comes to mediation for a small claims court, we can push for an amendment of the rules so that the timelines for mediation in a small claims court is made shorter. Why am I saying this? It's because mediation is purposely supposed to help parties restore back to the relationship we are in. For example, if I supply Rosie with coffee and I don't pay because COVID happened, but I get a door and get back my money, I would like to go back to the position I was where I could use supply and I get paid over a period of time. So to resolve the issue, I would encourage that you engage the mediation accreditation committee and find if that rule can be amended so that the period for the small claims court is made shorter. And again, I do agree with you that the adjudicators sitting in this court are also trained in mediation so that when they empower the disputants, then the disputants can be able to resolve the matter within themselves. I want to congratulate Ari for getting a good client in the small claims court. I'm encouraged because you are my student. You are doing a good job, and I hope you will come to speak to other students at the School of Law to know that it's not about our money. You can learn programs that change our communities. And to Stella and your team, congratulations once more, that after 1 year, we can talk about what you have done. That is what we are looking for in a greater judiciary. May God bless you. Thank you.
Thank you very much, Mwalimu. I do want to give everybody else an opportunity to make their closing remarks. And I would like to start with President Theuri. Maybe you can just take 1 minute to give your closing remarks as we wind up the session.
Thank you, Harry, for organizing such an insightful discussion. It's quite obvious from the interactions we've had that there's need for more civic education as to what this court can do, its jurisdiction, what it cannot do. But by and large, I think we are on the right track. I'm worried about the capacity of the court. I'm worried about the budgetary allocation that the judiciary is giving to this court. Because truth be told, when you go just slightly outside Nairobi, majority of the claims that are before court fall within the jurisdiction of the small claims court. When you look at the timelines of 60 days under Section 34, you can see that we are going to have a lot of challenges. I think from when the court started in Nairobi, we expected that there'll be an avalanche of claims on with regard to personal injuries, but the experience has been that the commercial cases have over time increased, and so it tells you that there were a lot of cases that were outside the formal system of the judiciary because for one reason or the other, the courts were unattractive for resolving some of those disputes, and primarily because of the time it took to resolve those disputes. So the challenge here is how then do we, if you look at the amount of cases that the registrar is saying are being filed, 150 cases being filed every day in Nairobi is absolutely, on one hand, impressive, and on the other hand, scary. And they are that diverse. So the judiciary has to put more resources. I think we probably maybe need about 30 or 40 adjudicators in Nairobi alone to be able to handle that workload to ensure that we're able to meet the aspirations of Section 34. And that will be the case when we go across the country. And then for me, I've always felt that the small claims court would be something like a different arm of the magistracy as we know it. We have about 500 or 600 magistrates as of now. And if we are to realize the aspirations of the small claims court and ensure that we meet the timeline set out in Section 34, I think we need no less than 100 adjudicators across the country. And that is really at the minimum. Is the judiciary prepared for this? There are question marks. So even as we call for more awareness and more education, we have to be aware of these restraints and constraints and challenges, and to be able to talk to the judiciary to be able to give us more adjudicators to meet this demand. And so there are challenges, but there are also very good stories that are coming out of the judiciary. And so it's a question of supporting the judiciary as it undertakes this, ensuring the implementation and the rollout of the small claims court across the country. But there is a need for us, each and every one of us, to call for greater strengthening and increased budgetary allocation for this court. But so far, from where we are okay. But a lot more needs to be done. So Harry and the rest of the participants, thank you so much for this very interactive session. At the beginning of, just about the anniversary of the Small Claims Court having been launched on 26th of April, 2021. Extremely, extremely impressive results, but also food for thought for us going forward. Thank you so much.
Thank you, Mr. President. I will ask the registrar to come in last, so we can probably hear from the rest of the speakers in the order which they spoke. Robert, are you still there? Okay, if Robert is not readily available, maybe you can hear from Pamba.
Thank you, Harry. Before I make my closing remarks, let me just address one of the questions that has been put forth about transfer of cases from the magistrates court. So section 13, whoever asked the question, section 13.3 contemplates a higher court. And in this case, that is the High Court. So for you to transfer a matter or a case from the normal magistrates court to the Small Claims Court, you will need to apply to the High Court for an order for that transfer. As such, once you get the order, then the registration of the case can be done. I believe Harry has successfully done so in more than 20 cases that he had previously filed before this court was launched. Now, on my closing remarks, I am happy that this session has taken place. We have not only gotten to know about the success and the challenges and the opportunity, but to a larger extent, we have had time to reflect about where we need to go next. And I say this because President Theory has outlined some of the issues that need to be taken care of for us to see the overall success of this court. So, and my happiness is because President Theory has been in this forum and the registrar has been here. I hope that those issues have been noted and will be advanced to the levels they deserve, so that when we commemorate the second year of this court, we will have more success stories and positive feedback on the steps that will have been taken in the second year of the court. And to everyone else, this is your court. It's a court that guarantees you the speedy resolution of the dispute. Come and let us have our dispute resolved. To the practitioners, enable this court. There are so many things in the rules and the act that you can leverage on, all the way from the mode of proceeding to how you can even respond to the claims with proposals and offers to settle. So let us also, as practitioners, be the enablers of this court for a successful second year. Thank you all the participants and have a great time.
Thank you, Pamba. We'll hear next from Kate.
Yes, Harry, I would like to thank you for organizing this. Can you hear me, Harry?
Yes, we can.
Yes, I would like to thank you for organizing this wonderful session. I hope we'll have more and more of these, because people need, it's a very good forum for sensitization, one that so many people have said is a requirement for this court. So this court has been operational for 1 year, and we are happy as practitioners. We are happy as mwananchi also. They are happy. You know, there's this saying that second to God fear small claims, because one day you're served with pleadings, the next day an auctioneer is sent with a proclamation. So it's because of the how speedily matters are being concluded in this case, in this court. This has not been seen in Kenya, so it's impressive. So the challenges that are there, of course, are for practitioners mostly. And the first challenge I would like to see addressed in the next, the second year, we will not be talking about adjudicators being so, what can I say, quick at dismissing matters for one reason or another. So they should be lenient in terms of service, seeing that this court ni ya mwananchi, hii koti ni ya mwananchi. Kwa hivyo, if they are too hard on, raia, it will discourage that court. On the part of the insurance, where I am right now, the major challenge comes in personal injuries matters. So you get that the person who's defending, of course, is an insurance company, will want to always adjourn the matter. We know who does this most because we've been there practicing. So there's a challenge and there's a discussion among practitioners. Should we just, do away with personal injury claims from the small claims court, because it's not actually, those types of claims are not helping us achieve Section 34. Should we just do away with that? It's also frustrating to the bench itself, because when you get these particular lawyers who are, they're just professional adjourners, let me call them that, but that is not what they are, then there's a problem. The other challenge is the bench needs to be sensitized in terms of liquidated claims and unliquidated claims. So you get that sometimes a default judgment has been entered. It's a liquidated claim. Certain adjudicators tell you to go for formal proof, others don't. So the practice is not uniform. Why is this happening? Usually we don't go for formal proof for liquidated claims. When a default judgment has been entered, let the person who the judgment debtor come in with an application to set aside the judgment. So I do not understand, or rather the practitioners do not understand the rationale of you going for formal proof hearing for liquidated claims. So I think that is something Honorable Kanyeri can take up with the team, and maybe to help us also as practitioners, have a consensus. We know once a default judgment has been entered, that's final, or we're going for formal proof. We need to have that uniformity. So all in all, this court has been successful. It's a good court. I'm excited about the opportunities. Mike has mentioned about the digital, the sphere of industry, entertainment industry. I'm excited particularly because of that. Well, you cannot split I don't advise you to split your 10 million to 1 million, but if it comes to that and you agree with your employer that yes, you can split 1 million, then well and good. And don't fear coming to court that you'll pay. This particular court doesn't have very high fees for advocates. You always use the lower scale. So at no point will your claim for 1 million go beyond the fees to go beyond what you don't expect. It will always be on the lower scale. So, and also remember, for mwananchi, you can actually just walk in. You can walk in the registry, and you're giving that form, and you fill and you actually represent yourself. So you're not denied that opportunity to go to court representing by yourself. You can also use a representative. All you have to do is to give an authority for them to act. So I'm excited about I'm always excited even going against a respondent in person, because now they also get to know how the court operates, and they're so excited. They're like, this is a very good court, even if a judgment will be against them. So Honorable Kanyeri and the team, thank you so much for the great work. We look forward to working with you, and of course supporting the court in all the procedures and everything. Any help you need from us, we are always there. Thank you. Thank you, Harry.
Right.
Good
Thank
job.
you so much, Kate. clearly we still have a lot of room to discuss the things about the court, and if we had the opportunity, I'm sure we'd keep on going, but we don't have too much time, so I will kindly ask the rest of the speakers to try and keep their closing remarks brief so that we can end in a good time. And I think the next person to speak is Gashao.
Thank you, Harry. I think for me, one of the greatest assets in any business is goodwill. My feeling is that there's goodwill from the court and from the justice system in general. Excuse me. And I feel, therefore, if there's just more sensitization, there's a chance justice will get to the people, which is the aim, to get to people more quickly. And then we can avoid at least fewer cases of people trying to take matters into their own hands. Thank you once more.
Thank you, and a good point you bring up. Mwalimu, is there anything you wanted to add?
Ari, thank you. I think I've already said what I must say, but just to, like I've said, to encourage parties to make use of this code, and especially the business community, to see to it that they can go back to where they were before. And you and your team make use of Kenya School of Law as a platform of training, so that more professionals will understand how this court works. I hope that soon, because I've seen you are going to Mombasa, Honorable Stella, that I'll see you in a radio station, either Baraka FM or One FM, speaking to people in Kiswahili about the small claims court, because we have a lot of matters below 1 million, and that then can be replicated in the stations around the coast. I'm passionate about that because that's where most of my practices are, although I practice in Nairobi. And make use of the law schools so that during the legal aid clinics, parties can visit the desk and empower our parties. Again, on the other hand, you can partner with organizations like Kituo cha Sheria to assist litigants in terms of filing those claims. Otherwise, thank you very much, and God bless you for the great public service you're giving to this nation. Asante sana.
Thank you very much, Mwalimu. We can hear next from Annabelle.
Harry, thank you for the opportunity to speak, and also for bringing together such great minds to educate us more on what the small claims court is all about and how it can benefit us. For me, what I would just encourage is that reach out to the business community to educate them in forums which may not necessarily be legal forums, but forums which they're already placed in. We have a forum, an SME forum, which educates the SMEs, and we'll be really keen to work together because it's a very great initiative for small businesses, for micro and small businesses as well. So I'd really be keen to be involved in more of this because I think it would be a great information, important information for some of the organizations that we collaborate with and some of the organizations that we support. But thank you so much for this, and I'm wishing the small claim court a lot of success and to even increase your ceiling even more so that you can capture a lot more of the businesses within the SME sector. Thank you so much.
Right, thank you very much, Annabelle. Rosie?
Thank you, Harry. Harry, I guess mine is to congratulate you because evidently you have organized this forum and there are so many success stories. It is my prayer, I don't know if that's the right word you use in your legal lingo, but I've heard it said often. It is my prayer that there are more and more success stories that trickle down to the mwananchi, because I would like to see that the domino effect is that because of a certain fear that justice will be arrived at, people take it upon themselves to be good and, make good what is due of them to their suppliers or anyone else. Because I'd like to go back. I know there was talk of mediation and all, but it must be accepted that really the court, because of previous experience, has really been our last resort, not our first resort. It is after multiple trials of trying to come and have someone pay, multiple trials of informally trying to reach an agreement, even if it's on installments, even if it's waiving certain amounts, that we then choose this route. The fact that we are seeing successes, I hope there are more and more successes, and the domino effect is to change the mindsets and to remove this punitive culture. And again, I'd like to see this extended. Someone said that $1 million is a high figure compared to other jurisdictions. I think it's fair for Kenya to have $1 million, but I do know that in Canada, it's up to $35,000. And yet they have a strong justice system when it comes to, just little things like listings. Listings are serious because once you are listed for 7 years, you're not credit worthy. So here we've got a long way to go, but once again, it's a promising initiative, and congratulations for the fantastic achievements in 1 year. Looking forward to seeing this spiral into not just seeing many cases, but spiral into successful stories down to the mwananchi and down to business getting to be more honest and just. Thank you.
Thank you very much, Rosie. Mike?
Harry, next time I have to go before Rosie. She keeps taking words out of my appearance of security is much more important than security. I'd rather have a huge bouncer who doesn't know how to fight than a skinny karate master who everybody wants to challenge. And for me, the small claims court is that bouncer, that person who discourages someone from offending the smaller artist, the smaller person. Would I want to go in without a lawyer? That's something we discussed. I kind of feel like it's going in my mind, am I going into a gunfight with a knife? I would not want to face Kate, not knowing the law. Is there a way to actually guarantee me, the smaller person, that I'll get due course without knowledge of the legal system? Maybe the Kenya School of Law can start developing templates for engagement. So through student projects or whatever it is that allows people to actually understand, if you engage using this process, it's very easy for the small claims court to process your claim because you got a contract, you got this document signed, and if you cross your T's and dot your I's, then it's going to be covered so much easier. That might help with the efficiency of the court. Beyond that, happy birthday to our bouncer. Hopefully we'll do this again next year with more efficiency. And yes, all the best.
Thank you very much, Mike. Finally, I would like to hear from Honorable Registrar Stella Kanyiri, who can make our final remarks before we wind up the session.
Harry, as you can see, I can't stop smiling. I'm excited. I'm so happy. So first off, I am thankful, very thankful for you, Harry, and for Swala Nyeti for hosting us, and for the panelists for making time to have this discussion. And we've gotten enough feedback from the panelists and from the questions, and we're taking notes. So we are committed to continued engagement with our stakeholders. We've heard of the issues of the lack of awareness. We agree. We've barely scratched the surface in terms of creation of awareness amongst the masses. I think we've managed to only hold about less than 10 sensitization forums. So we're hoping to hold more in the new financial year. So finally, I think as a small claims court, we remain committed to being a court of excellence. We want to continue pushing the envelope because we realize that we do not exist for ourselves. We are here to serve the Kenyan people, and that is why we receive a salary at the end of the month. So that one is a word that we can give you as a court, that we remain committed to doing so. And I cannot finish without telling you, Harry, that for the period that the pilot court has been in operation, It has adjudicated commercial disputes over half $500 million shillings. And cumulatively, between the commercial cases and the civil cases, the total value of cases determined is around 866 million shillings. That is under 1 year. So this is money which would have been locked up in litigation for 1 year, 2 years, 3 years, 4, 5 years, but has now been unlocked within that short period of under 1 year. So we are hopeful for the prospects that the court holds, and we can only hope for bigger and better things. Thank you very much.
Fantastic. What a way to end that discussion. I will echo Mike's sentiments. Happy birthday to the court and to all its users. I want to thank every single person who participated, to the fabulous panelists. I think you contributed richly to this discussion. To the partners who supported, LSK, the Small Claims Court, the SME space, we really appreciate you. And last but not least, I want to thank our technical partner, Genesis Design Factory, who made this world-class presentation possible, and to the production team of Sean and Mara, who worked hard to make this event the success it was. I think this is not the end of the conversation. We shall have several more. The session has been uploaded to YouTube, so you can take time to watch it later and share with your friends. But let's keep speaking and show up tomorrow at the open day at Milimani Small Claims Court. With that, it is my pleasure to say good night and goodbye.